Welcome to The State of Us.
Beyond mainstream cable news and party lines, with a millennial and a boomer, The State of Us pushes past the noise and uncovers all the issues that matter.
Here's your host, Justin T. Weller.
Today, we're tracking the major Supreme Court decisions from this term. With the arrival of Justice Amy Coney Barrett, President Donald Trump's third appointee, the court has been significantly transformed with a slight conservative majority into one that tilted right by a 6-3 margin. That said, today we're going to look at what are the notable decisions that you may have missed from the Supreme Court recently. There's been a lot going on, and some of the Supreme Court news has kind of been in the background. So we're going to bring it to the forefront because there's a lot of important cases. We're going to talk about how the court ruled and also how Americans feel about the issues. Sometimes it matches and sometimes it doesn't. We've got a lot to get through today, but of course, no conversation on the Supreme Court or where the country stands could be complete without
TrueChat senior historian and an educator of more than 30 years. Here is your friendly redneck liberal, Lance Jackson.
Well, the summer and fall with COVID and Afghanistan and everything else, we haven't heard about the Supreme Court, but they've been making some very poignant decisions as we've moved through the summer. And I think it's very worthwhile to spend some time looking at them. And that's our word of the day, poignant, an adjective, 2 syllables, Poignant. It means sharp, biting, penetrating, or pointed. And I think that is a good definition for any Supreme Court decisions. And I think you'll be surprised as we look at these with maybe not the decision itself, but the reaction of the American people when given this, where they agree and where they disagree. But remember, that's not the court's job. The court's job is to read the Constitution and make the most constitutionally sound, poignant decision that they can. So without further ado, Justin, which one is first?
Well, I'm not sure that the Supreme Court's decisions have to be poignant, right? They don't always have to be sharp or biting, although often they are poignant, right? So that's what we're looking at today. Some of these certainly are poignant, and we'll have to determine whether or not you feel the same. You'll be able to send us an email throughout the show, podcast@thestateofus.org. Send us an email, podcast@thestateofus.org, and tell us what you think. So first up is voting rights. And if you want to read this article for yourself, it's linked at thestateofus.org. So ultimately, the court ruled that Arizona's restrictions on voting in the wrong precinct is lawful, and that the state can forbid voters from relying on another person to collect and drop off ballots. That's a 6-3 conservative liberal bloc split on the Supreme Court. Now, where does the public stand? Well, the public, taking Democrats, Independents, and Republicans together, disregarding entire ballots from voters who voted outside of their precinct is unlawful, 51% of Americans. Discarding entire ballots from voters who voted outside of their precinct is lawful, 49%.
You know, this is an interesting decision, and hopefully, I think we know that the reason is probably because of making sure we're tough on election fraud, even though it's never been proven that there's been huge fraud out there. It is still an interesting case because Arizona is one of those states where the Trump team challenged the results. So
this also affected, by the way, not just the decision about whether or not to disregard ballots that are submitted at the wrong precinct, but also who should be able to drop off ballots.
Right.
So voters should be able to rely on another person to collect and drop off their ballots versus states can forbid voters from relying on another person to collect and drop off their ballots. That's a 50-50 split among all Americans. Democrats, a 70-30 split. Republicans, a 27-73 split. And your independents, 46-54%.
Well, and we're seeing it around there, but all around the country, but it just says that states can forbid. It doesn't mean they have to. So the decision is, and we know that there are states that will do that. We've seen them in the news, and there are some states that will say, we can forbid voters from relying on other people to collect and drop off ballots. We're going to do that. We're going to make it harder to vote. And you know how we feel here at the State of Us. Anything that makes it harder to vote, we're usually not in favor of because there aren't enough of us that vote in the first place. So, but anyway, that's the way they ruled here during this summer.
The next one's interesting because it's not something that we all talk about as frequently, which is donor disclosure. So in Americans for Prosperity Foundation versus Bonta, the court ruled that California's requirement that charities report their major donors to the state violates their First Amendment rights. So this is a 6-3 decision, again, conservative versus the liberal bloc, where the public stands. Requiring nonprofits to report their major donors to the state does not violate their First Amendment rights. 60% of Americans agree with that statement. And this one I think is notable because it's one of the largest agrees across the board in terms of the public is of the opposite opinion of the Supreme Court. So all Americans, 60%, Democrats, 74%, Independents, 61%, and Republicans, 44%. So generally Americans feel, 6 out of 4 Americans, right, disagree with this decision by the Supreme Court, Lance.
Yeah, and almost, you're at 44% Republicans, almost half of Republicans, that age-old
I don't
question.
like this one.
Well, no. And again, though, the Supreme Court is going to stand up for, and we could get into a little bit about why maybe the conservative side of the court doesn't want this. Let's face it, typically people who have a little bit more money are willing to make big donations to places that might be a little more controversial, maybe, or candidates that are controversial. And the conservative bloc of the Supreme Court, you hope that they don't do those kinds of things because that's not their job. But, it's hard for me partly to see how this is a First Amendment right. It's like freedom of speech. Well, the fact that I donate money somewhere, how does that fit freedom of speech?
Well, I think the court's argument over the years has been it's an expression of speech, right? You're expressing yourself by donating money to a cause. But the thing that I don't get is...
But if I write it to a letter to the editor, I sign my name.
Right.
So why not, if I donate money to a cause or to someone or something, why isn't my name attached?
Yeah, I'm not sure. We need to read the decision because I guess I don't recall the Constitution anywhere in the First Amendment saying that you have the right to an anonymous public opinion. You have the right to an opinion, right? And you have the right to express that opinion. But I'm not sure that it's guaranteed that you get to be anonymous in expressing that opinion. In fact, I think there's places where it would suggest that you, in fact, do have to put your name to your opinion.
Here it is. As I read some of it, it says, people think that making the nonprofit organization report names is an attack on their First Amendment rights to free association because it might deter people from financially supporting them. So this isn't going about necessarily individuals. It was brought by private nonprofit organizations who said, we don't want to have to report the names of our donors to the California Attorney General.
Yeah. I can see how, I guess, working in the nonprofit sphere, I understand the importance of when you have people that donate money who want to be anonymous, know, and for genuine reasons, right? They don't want it to be about them and them donating. At the same time, I think it's also important that we point out to people, these are not usually the same types of nonprofits that we're talking about. Okay. Because for example, federal 501c3 organizations where you get your fully tax deductible contributions, which are the ones where you have those nice noble donors, right, who are given big chunks of money and they don't want to be mentioned, they can't give to political campaigns or candidates. It's prohibited by federal law. I don't think that, especially private 501c3s, I'm not sure that they should ever be compelled, to release their donor list unless it's in a legal proceeding or something. But that's not what we're talking about here because 501c3s can't do that. So you're not talking about, the campaign to save the rainforest here, right? Or the youth center or whatever. That's not what you're talking about. You're talking about usually political nonprofits, right? In fact, 501c3 regulations are pretty specific about barring and prohibiting 501c3s from even the appearance of engaging in political campaigning for candidates. So, I mean, I think it's a nice thing to sort of hide behind, but I feel like it's kind of a hide behind. I mean, if you're donating to a political nonprofit, your motivations are political. And Americans, right? 6 out of 4 Americans are on that page.
Well, yeah. We're all about transparency these days. I mean, let's know what's going on.
So we also need to look at students' First Amendment rights, union access to workplaces, and student athletes, among other things like the Affordable Care Act. There's a lot to talk about, but to find out where the Supreme Court stands on these and what else you might have missed, keep it here on The State of Us, and we'll be right back.
We are The State of Us. Here's your host, Justin T. Weller.
Word of the day competition. At the end of the first segment, we've got, I guess we'll let Lance report his own score. But I think I have him at 2 or 3. And I got me at 3. So what do you have, Lance? Are we in agreement here? Or?
Sure.
Okay.
Yeah, it's a very poignant observation on your part.
Right.
That the score was
We'll say
close
that you
to
had
even.
2. Now you got 3, so now we're all tied up,
Okay.
I think is how that works. So students' First Amendment rights. This one, this is an interesting one because it was an 8-1 decision by the Supreme Court. Okay. And in fact, the one objection was actually one of the conservative bloc members of the Supreme Court. So in this school district case, the court ruled that a Pennsylvania school could not punish a student for off-campus speech because it violates the First Amendment. So in other words, if you're a student, right, and you go do something and you're not at school, right, you're not at school's time, on school's time, the school cannot punish you for those actions when you're not at school. Specifically in this case, saying something or posting something that maybe is against your school's code of conduct, but again, you're not at school. 71% of all Americans agree with that. Democrats, 64%, independents, 72%, and Republicans, 78%.
Well, I think that's the important part to realize, the important phrase that they say are right off campus. You cannot do it on school grounds. You cannot bring it in. You cannot post it in the building or say it in the building or on the grounds. But when I go home, I go home. I mean, I think that, as someone who's
you like this decision.
Lifelong in education, that's what the First Amendment's all about, is being able to say something without being punished in some other arena like this. When, now within that arena, we know that the Supreme Court has ruled on, the age old adage, whether it's true or not, but we used to say in school, you can't yell fire in a crowded theater because you're endangering the lives of others. So, there are free speech limitations, but when you're in the privacy of your own home or you're on your own time in your own place, then that's what it's supposed to be. We should be free to talk and to discuss and to do what we want to do. Obviously, this has to do, it doesn't say it, but it has a lot to do with the internet. It has to do with things getting posted, student complaining about how they were treated at school or what they think of certain teachers or administrators. While I don't like that, they have the right to do it, I think.
Yeah, I don't have a lot more to say on that one, Lance. I mean, pretty much on that same page. I think there's some nuances that could be discussed, but ultimately, I think we're mostly all of the opinion that at least 7 in 10 Americans are of the opinion that schools are responsible for you during the school day, not necessarily once you've gone home. Union access to workplaces. I think this one's interesting. I want to give us a little time for this because basically in this case, a 6-3 decision by the court, they ruled that California cannot require that union representatives be allowed to meet with farm workers at their work sites because such a requirement violates the constitutional right of the employers. Where does the public stand? So the question was, states can require that employers allow union representatives to enter a company's private property. 48% of the public stands on that side. 52% of the public stands on the side of states cannot require that employers allow union representatives to enter a company's private property. Democrats are 65 to 35 in support of allowing states to make the requirement. Independents, 46% to 54%. Republicans, 31% to 69%. It's an interesting question. I'm not sure that we have enough time to really dive super deeply into it today, but that goes to that fundamental question of, how much forcing can be done, right? In other words, you have the right to a union. Do you have the right to organize your union on the company's property, or do you have to go someplace else to organize your union? Can you force the business, even if they're not supportive of the union, to give you access to their property to organize your union?
Well, you run into these where you're in California and along the West Coast and some in the South as well. You have these huge farms that have places for the workers to live. And so the workers never leave the business because they have housing on the farm. And so when the workers are on their own time, they're still on the farm. They're still at the business because the business provides housing as part of their pay. So therein, I think, lies part of the rub, and then obviously we're worried about if a union is organizing and the owner doesn't want that, even if I'm free to leave the workplace, the owner can then watch me leave the workplace. And do I lose my job for, quote, some other reason because I went to a union meeting that was taking place a mile down the road, which is off of the farm? So that's, I think, where you start to get into this a little bit. I think, most of us would say, well, it's your place of business. You can have whatever you want on it. But then if you're going to then attack people's right to work because they are listening to someone trying to organize a union or to get them to join a union, then I think most of us would say, well, that's not right. You don't have the power to stop them from thinking about it. And I'm just going to throw this anecdotal piece in. I was reading a copy of USA Today the other day, and there was a poll in the bottom left-hand side of the money page where it showed the graph since post-World War II, the number of people in the United States who support the right of unions. And, it's been going down since the 1960s. I mean, the rise of unions after World War II was one of the reasons why the middle class and the workers became so big and so powerful that people don't talk about, in my opinion. And since then, union activism and people who support unions have gone down. But currently, 62% of all Americans support labor unions.
Which is even more interesting in the context of this, because a slight majority of Americans say that, right? So you definitely have a definitive majority that say they support labor unions on the whole. You have a slight majority that says, though, that they're not in favor of forcing private entities to allow the union to organize on their property.
Sure. And there's a difference there. I mean,
but I think it speaks to the dichotomy of the nation, right? Because it's too often that we do that whole thing. Well, you're for unions or against them. Well, okay, maybe that's true, but just because you're for the existence of unions, and I guess that's the point that I'm making here as far as where I'm at, I get the point you brought up, Lance, about this particular case. My concern would be, and I think the conversation that has to be had, is what type of precedent are we setting up, right?
Sure.
Because now do you get into, okay, well, we've got, some factory workers that all live off site here in Urbana, Ohio, and they want to have a union, so they're going to force the factory to let them use, one of their conference rooms to have their union meeting. I don't love that, because you and I have talked a lot about the government already does a good bit of telling people what they can and can't do with their property. And this feels like an expansion of that, unless the argument's going to be that this was a narrow decision based on the specific parameters of the reality that these people happen to live. They resided at the place they also worked, which is unusual, right? I mean, most people don't live at their place of work. So, and I can see how in that instance, there's a nuance to the argument. So we got to move on though. Student athletes. So this is one of the, I think, two, right, that we're looking at today, which was a unanimous decision by the court. So no liberal conservative split. It was a 9-0 decision on student athletes. So this was the NCAA. The court ruled that ultimately the NCAA may not bar modest payments related to academics to student athletes in the name of amateurism despite the antitrust laws. This is one where Americans are split 50-50.
I think the public is living, some of the public is living in a pipe dream about amateur athletics and how amateur it is, particularly at the highest levels. It's still very much an amateur athletic in the Division III, maybe even Division II somewhat.
But Ohio State college football,
but when you're talking,
a multi-million
the National
dollar
Football
business.
Championship, the CFP playoffs, or you're talking March Madness in Division I basketball, folks, that's not amateurism. That's not in the source of, you're hard pressed even when you talk about the Olympics anymore, which we just currently had, the Tokyo Olympics, of being pure amateurism anymore. There are stories where there are pure amateurs, but not in the sense that most of us would like to think about it when we go to our local junior high or high school and watch the kids play their sports.
Yeah, I guess my thought on this, Lance, is there's the way I want it to be and then the way that I believe that it is. And that speaks to what you were saying. What I want it to be is I want it to be that no, college athletes should not be paid. They should be playing a sport for the sake of the sport, for the fun, right? For the amateurism of it. But that's not how it is in the biggest of cases. And they're the ones we're talking about, right? We're not really getting into your Division III athletics where, as you pointed out, it really still is an amateur sport. We're talking about at the highest levels of the NCAA. These are sports that are tons of money is being made off of, right? And you are, in many cases, if we're being realistic, these athletes, right? Yes, they're in college, but for many of them, the sport is what they're looking at is trying to build some kind of career around. So there shouldn't be any illusion by everybody that's involved that they don't have some sort of right to participate somehow in what is already being benefited from at a professional level. Mm-hmm. They're just being exempted from it.
Well, and the university is making money off of their likenesses and off of their work and activity because, there's not only are they selling TV rights and radio rights, media rights, but they're also charging $300 and $400 a seat to have the opportunity to watch said athletes perform. And it's like to not say that they don't deserve a cut of the pie, it seems wrong to me.
We've got more coming up, though. The Affordable Care Act. This is one where the court ruled in the opposite opinion of the
majority of Americans.
So we've got that coming up. Religion and gay rights, another unanimous decision by the court, and COVID restrictions. The court was split there. So lots to come. Keep it here on The State of Us, and we'll be right back.
We are The State of Us. Here's your host, Justin T. Weller.
The returns on the word of the day were weak in the second segment. Poor showing by Justin and Lance, each adding one, keeping it at a tie score. So poignant is what we're talking about today, a sharp or biting response. And I think in the instance of the Affordable Care Act, it was indeed a poignant decision. So ultimately, it was a 7-2 decision, and two of the minority opinion were actually conservatives. So you had several conservatives, 4 conservatives joining the 3 liberals to ultimately make up this decision. And it was California versus Texas. The court effectively upheld the Affordable Care Act in a third major challenge, ruling that the plaintiffs did not have standing to sue. The court sidestepped the larger issue in the case, whether the law can stand without the provision requiring most Americans to obtain insurance or pay a penalty. So where do Americans stand? And this is the ultimately, right, the part that we're looking at and the interesting part, which is the individual mandate provision is a tax and is constitutional. Well, 44% of Americans agree with that. The majority of Americans, 56%, say that the individual mandate provision is not a tax and is unconstitutional. So even though the Supreme Court sort of sidestepped the larger issue, they've effectively left it in place. It's important to remember that under the ACA, there is a tax penalty for not buying health insurance. The so-called individual mandate under recent legislation has set the tax penalty for not buying health insurance to $0. So some people believe that because the tax penalty is $0, this means that the penalty is actually not a tax and it exceeds the federal government's power to tax and is unconstitutional. So the whole original legal argument behind the individual mandate is that you are actually being taxed, right? If you don't have health insurance. If you have health insurance, you're exempt from that tax. Okay, that was the right legal standing of how we structure it. When the Republicans set the punishment to $0, you now get into this strange argument about, well, you're not really being taxed, right? I mean, if the tax is $0, are you being taxed?
The 7-2 vote was very poignant in that it just said the plaintiffs did not have the right to sue. So the court didn't really vote on a 7-2 vote saying that everything's okay. It's just saying, yeah, you don't even have the right to bring this to us. So a very minute reading here of what was going on. And basically the court said there are bigger issues, but there are bigger fish to fry with this. And this is not one of them that we think you have the legal right to even ask about. And we're not going to rule on any other part of it until you bring us something else. So I think that kind of wraps up my feelings on it, is that I think the court would like to say more about this law, about the Affordable Care Act, but I don't think any of, obviously a 7-2 majority didn't think that this was the case where they had any legal standing to say anything about it.
The other survey component here was asking Americans if the individual mandate is deemed to be unconstitutional, should the rest of the law get to stay? And the majority of Americans, 53%, agree with that sentiment. So even though a majority of Americans believe the individual mandate should go, is unconstitutional, then a majority of Americans also believe that the rest of the law should get to stay even if the individual mandate doesn't. Problem is, as we've talked about before on a larger issue, the basis of the practicality of the ACA is in part based around the idea that you have to have insurance. So Americans want what is it? They want their cake and eat it too. So, it's kind of one of those, a larger conversation for a different day sort of things, but not a realistic expectation without some changes, I guess is my feeling there. So religion and gay rights, the court ruled in a 9-0 decision that Philadelphia violated the First Amendment when it required a Catholic agency to work with same-sex couples when screening potential foster parents. So this is interesting because, the court's 9-0. Here's where the public's at. Requiring religious agencies to allow foster children to be placed with same-sex couples does not violate their First Amendment rights. 48% of the public says that. 52% of the public says otherwise. Your split along party lines here comes 61% of Democrats says it does not violate the First Amendment, only 43% of independents, and only 35% of Republicans. So it is an interesting question, partly because we've allowed religious institutions to become part of the foster care system, right? For example, when you look at Americans' opinion on this with general government agencies, it's almost not unanimous, but a large percentage of Americans agree that, well, a government agency, yes, needs to allow, as long as people meet the criteria, then they should be allowed to adopt. When you get into can you force a religious institution, which is participating in the foster care system? Again, here's the thing, right? I'm going to tell you that my opinion on this is you want to get foster kids adopted, right? So if these are good people who are trying to do the right thing, whether it's 2 men, 2 women, a male and a female, I think what we know is that the data tells us it is better for these children to get out of the foster care system than it is to stay in it on the whole, okay? Regardless of the gender of the parent or parents. So that's where I feel like inside. On the surface, though, you have an interesting legal question here about, again, what can you force somebody to do? I don't think they should be denying this. I disagree with that. But do I think that that we should be able to force them? Well, I'm not sure. Again, I guess if you want to participate in a government program, right, you're back to the whole thing. You don't have to participate in the foster program if you don't like the requirements of it.
That's right? The bottom line, right? There's nothing here about schools or whatever, but it's like all these people that are saying, well, I don't want to be a part of it. Okay, then don't. And pay the price. Go somewhere else. This is what the government is offering. This is what the government is saying. And so it's, I know where you're coming from. Again, the court agrees because they're saying since it's a private organization, we're not going to have the government step in and say, control the private organization. And that's what the decision is on. I'm sure the vote by the Supreme Court would be different were it, are you excluding them? And of course, I totally agree with you that concerned adults who are looking out for the welfare of children are always beneficial. It doesn't matter what the makeup of the relationship is. 100%.
So our last 2 here, well, the next one really is sort of another religious case. It's a 5-4 decision, and you had one of the conservatives departing. So you had just a slight majority here. And ultimately it was that the court ruled that New York could not prohibit in-person attendance at worship services because it violated the Constitution's protection of religious freedom. In other words, their decision was along the lines of the Constitution explicitly says you do have the right to worship, in the way you see fit. They felt, I believe, and I don't want to not do justice to this here, that ultimately the challenge came in with they could not find where the Constitution allowed us superseding that right for public welfare, which is interesting. But again, when you look at the Constitution, there's references, but you have a hard time pointing to stuff that says, well, yeah, you can supersede this in this instance. So, I don't know. Let us know what you think on that one, I guess, because it's a bigger conversation, I guess, about, the superseding of rights and when you're allowed to do certain things.
Well, it all comes down to what I was taught back when I was a sophomore in high school, and that is I have my rights until I step on the rights of others. So if I go to a large function and I become ill and I make others ill, have I now just stepped on the rights of others? Or if I take up a hospital bed that a heart attack patient needs because I went to a large function and got sick at the large function, have I just violated the rights of another? And that's the way I would pose the question with that question is, when do we have to acquiesce our rights
for the rights of somebody else?
Because we're stepping on the rights of others. We have our rights as long as we're not stopping other people from having rights. So I guess that's where I am. That's just always stuck in my head that I got handed a handbook for school. I had my rights and responsibilities. And there you go, responsibilities. With your rights come responsibilities. And you don't have the right to inflict on others' rights. That's part of the responsibility of living your rights.
And it's a bigger conversation because some of the most controversial Supreme Court decisions have focused on, when does one group's rights supersede the rights of another group? And it's tough because unfortunately in our system and in our Constitution, there are times where those are contradictory, right? The Constitution says I have the right to X and you have the right to X. And in order for us to both have those rights, somebody's got to lose out. The last one was life sentences for juvenile defenders. And this was, I think...
Offenders, not defenders.
Yes, offenders. This one, I think, was the most interesting, where you had a 6-3. So majority, again, the conservative bloc versus the liberal bloc here, ruling that basically the court ruled that juvenile offenders do not have to be deemed beyond the hope of rehabilitation before a judge can sentence them to die in prison. 71% of Americans disagree with this. Every group, by the way, is over 60%. So Republicans, Independents, Democrats, all are over 60% in their disagreement with the Supreme Court's decision. I'm right there with Republicans, Democrats, and Independents on this one. If you are going to sentence some juvenile to life in prison, you sure as heck ought to be able to demonstrate that they are beyond hope of rehabilitation. Sorry, I don't have a lot to say on that one. That's absolutely crazy. You're going to lock up a kid for doing something which may have been incredibly stupid, but you're going to do it for life and not have already demonstrated that there's no hope of bringing them back.
Before you sentence them to life without parole.
Right. I mean, if there's no hope, okay, that's a different conversation. But if you say, oh, well, yeah, we could rehabilitate them, but you're going to let a judge sentence them before you do that. Sorry. Anything else, Lance, on that one?
No, I mean, it's pretty interesting because there's no other number.
My response was poignant.
That's I guess so. At least you wanted it. It was very strong.
Oh, okay. Sharp and biting.
Yeah. But I think and when you see over 60%, it's 64% is the lowest number who disagree with the Supreme Court. So it's all, at least 2 out of 3 Americans disagree, but the court has the right to do that. And I think that's very important for people to realize and understand. But that's what we're doing here, right? I mean, we're trying to have these kind of difficult and poignant conversations about these issues that you're not hearing a lot about in the rest of the media. And that goes along with our mission here at True Chat, and that is to educate people by providing honest, open, and respectful conversations. And we've done that today. And we brought up some things that, if you're like me, you'll follow the news, but you really hadn't heard a lot about this Supreme Court that many people were worried about or happy about getting back when Donald Trump was president of the United States. And so when you're having this conversation today, hopefully you share it with others. They find it interesting and tell them that they can find other good conversations on events that are going on in the world on Spotify, Overcast, Stitcher, Apple Podcast, and everywhere podcasts are found.
Final tally, Lance takes the win for the day and a 6-5 victory over the host. So
it should have been 6-3 or 5-4, right? It would have been ironic there.
Yeah, almost. So let us know what your tally was. Send us an email, podcast@thestateofus.org. The podcast is available Tuesdays and Thursdays by 4 a.m. And on the weekends, you can hear us in select talk radio markets. Remember, this Saturday is a special edition release of the podcast only, where we continue to cover the Facebook files and all the indiscretions that Facebook has been making. Some big stuff happening there. Be sure to tune in. For the State of Us on True Chat in Urbana, Ohio, I'm Justin T. Weller.
I'm Lance Jackson.
Special thanks to our producer, Bradley Butch, and thank you all for tuning in. We'll see you next time. Be the change. Be sure to check out our website, thestateofus.org, for books, articles, and all the ways to tune in. thestateofus.org.